What are the subject matter of copyright under the Copyright Act 1957? Copyright is a form of intellectual property that gives the creator of original works exclusive rights to use and distribute their work, usually for a limited time. The Indian Copyright Act 1957 governs the law relating to copyright in India. Statutory provision section 13 of the Copyright Act 1957 defines the subject matter of copyright. According to section 13 subsection 1, copyright subsists in the following classes of work: original literary works, original dramatic works, original musical works, original artistic works, cinematograph films, sound recording, etc. So the work must be original, not copied. So what are the categories of the works under the Copyright Act? The literary works. Literary works includes novels, poems, textbook, essays, computer program, etc. Example, a CA textbook written by an author. Dramatic works includes the scripts for plays and choreographic works, etc. The script, example, the script of a theatre, drama or a screenplay. Number 3 is musical works. Musical works refer to compositions of music, melody, not lyrics or performance. For example, instrumental notations composed by a musician. Artistic works include the painting, sculptures, drawing, architecture, etc. Example, the logo design, cartoons, digital art, etc. Cinematograph films. Visual recording with sound includes feature films, video clips, etc. For example, Bollywood movies, educational videos, etc. Sound recording, recording of sound, music, speech, or any combination. Example, recorded song, albums, and podcast. Essential requirement for copyright protections in the work must be original, must be fixed in a tangible medium, that is written or recorded. Skill and judgment involved in creation, no merely mechanical work. Exception: what is not protected: ideas, procedures, methods of operation, official government acts, names and titles, blank forms or content lacking originality. So these are not the copyrighted, these are the exceptions of the copyright. And the relevant case laws, in case of the, if I get the relevant case laws, the relevant case laws is the Eastern Book Company versus D.P. Modoc. The Supreme Court 2008 1 SS Supreme Court cases 1. Supreme Court held that the originality means the applications of skill and knowledge. The case dealt with the copyright in head notes of the judgments. If I go in detail, what are the facts behind this case? The Eastern Book Company versus D.P. Modoc 2008 1 SSC 1. The facts of the case is the Eastern Book Company was the publisher of Supreme Court cases, law reports. EBC, the Eastern Book Company, claimed the copyright over copy edited judgments, paragraph numberings, head notes, footnotes, cross references. D.P. Modoc and others used these judgments and formatting in electronic databases. EBC alleged the copyright infringement. The issue here are whether copy edited judicial judgments, including the paragraph numbering and minor editorial changes, qualify as original literary work under the Copyright Act. Number 1. Number 2. What is the standard of originality in Indian copyright law? The case goes to Supreme Court. Supreme Court rejected the suit of the Brew doctrine, adopted the modicum of creativity, that is the minimum creativity standard. Supreme Court held that the bare judgments are in the public domain. Simple editing, formatting or paragraph numbering lacks originality. Head notes involving skill and judgment may qualify for protection. EBC does not have copyright over the judgment as such. So From this point of view, we can get the legal principle that originally requires skill, judgment, and minimum creativity. Originality requires the skill, judgment, and minimal creativity, not mere labor. So, in this case, therefore the Eastern Book Company does not make any copyright against their literacy or against their judgment, against their electronic databases or Supreme Court judgment. And another case law is Indian Express newspapers versus the Union of India AIR 1985 Supreme Court 515 held that the freedom of press does not affect the validity of copyright law. What are the facts behind these cases? The fact is, Indian Express newspapers challenge the levy of customs duty and taxes on the newsprints. Though primarily a constitutional case, the court discussed the importance of newspapers and their intellectual content. The case involved freedom of press and economic burden affecting publications. The issues are whether excessive taxation on newspapers violates the freedom of speech and expression under Article 119(1)(a), to whether the newspapers enjoy the protection as intellectual property. The decision come from that Supreme Court held that the freedom of press is a vital pillar of democracy. Newspapers involve intellectual labor and creative efforts. Excessive taxation indirectly restricts the disseminations of ideas. Any governmental action affecting the newspapers must be reasonable and non-arbitrary. So, copyright references recognize the newspaper as copyrightable literary works, emphasize the value of the original expressions in journalism. So, from this point of view, from this case law, we can get the legal principle. The creative and editorial content in newspapers is protected as intellectual property. Now, another case, University of London Press Limited versus University Tutorial Press Limited 1916 2CH601. Therefore, this is the case of the Court of Chancery UK, United Kingdom, held that the even examination papers could be copyrighted if original. The fact of the case is that the University of London Press prepared the question paper for examination. University Tutorial Press reproduced the similar questions in their guides. Plaintiff claimed the copyright infringement. Issues are whether examination question papers are literary works, whether the originality requires novelty or literary merit. Recently, the court held that the question papers are literary works. Originality does not mean novelty or novelty or genius. It is sufficient if the work originates from the author. Copyright subsists even in simple, functional, non-creative academic material. So, legal principle here is originality means independent creation, not inventiveness. So, this is the case. So, there are three cases: Eastern Book Company versus D.P. Modak, and the Indian Express newspaper versus Union of India AIR 1985 Supreme Court 515, and the University of London Press Limited versus the University Tutorial Press Limited 1916 to CH601. So all these given us that what are the copyright subject matter. Now we get the flow chart. The subject matter of flow chart is Copyright Act 1957 section 13, original works. What are the original works? Literary works, dramatic works, musical works, artistic works, cinematographic films, and sound recording. So in conclusion, we can say the Copyright Act 1957 provides a comprehensive list of protectable works, encouraging the creativity by granting exclusive rights to authors and artists. The subject matter of the copyright ensures that the creators receive legal recognitions and commercial benefits for their intellectual labor. So, literary works, musical works, artistic works, idea, film, and sound recording. Literary work, book, article, software, codes, melody, tune, not lyrics, painting and sculptures, concept without expression, movie with audio visual, and song, podcast, and voice note. These are the literary work, subject matter of the subject of copyright.